6:14 a.m., June 18, 2026, Chicago, Illinois. 41 federal agents moved simultaneously through 3 entry points of a LaSalle Street office building. The lobby of 190 South LaSalle was quiet at that hour. The overnight security guard had already been escorted to a side corridor. The elevators were locked to a single floor. Outside on the street, 4 unmarked FBI vehicles idled at the curb. Headlights off, engines running. On the 14th floor, agents in tactical vests stacked outside the glass doors of Harmon Kreis & Vance LLP. One agent held a battering ram as a precaution. It wasn't needed. The firm's office manager, arriving early to prepare for a 7 a.m. client call, had already unlocked the main entrance. The doors opened. The agents moved in. The lead tactical element swept the reception area in under 4 seconds, fanning left and right past a row of client waiting chairs and a glass trophy case displaying the firm's professional memberships. A second team peeled toward the server room, following a floor plan obtained earlier that week through a sealed warrant. Estimated value of the financial network dismantled that morning, $91 million. 3 partners were in custody before the elevator reached the lobby. 14 servers were seized in the first 11 minutes. And somewhere inside that building, in filing cabinets, in encrypted drives, in printed ledgers that looked like ordinary billing records, was the paper trail of one of the most sophisticated Iran sanctions evasion schemes ever prosecuted in a federal court. This is the story of how a single wire transfer flag, caught by a junior IRS examiner in March 2026, unraveled a financial relay operation that had been running since November 2024. Harmon Kreis & Vance had been a fixture of Chicago's international trade legal community for over 2 decades. Its offices occupied the 14th floor of a building 8 blocks from the Chicago Board of Trade. The lobby directory listed the firm's practice areas in standard sans serif lettering: maritime law, international sanctions compliance, export control advisory, commodity trade finance. That last item, sanctions compliance, should have raised flags earlier. It didn't, because the firm's credentials in that space were legitimate, at least on paper. 2 named partners had published articles in trade law journals. One had testified before a Senate subcommittee on export controls in 2022. The firm maintained memberships in the relevant bar associations, attended the relevant conferences, and billed at rates consistent with its peer group. What the firm also maintained, beginning in November 2024, was a second function invisible to any client or regulator: a financial transit node for crude oil proceeds generated by an IRGC-linked shipping broker operating out of Sharjah, in the United Arab Emirates. The broker's name, as it would eventually appear in federal charging documents, was a UAE-registered entity called Fiscal Maritime Consolidated FZE. Its beneficial owner, identified in the indictment as an Iranian national operating under multiple travel documents, coordinated the movement of Iranian crude oil through a chain of intermediary tankers that flagged their cargo as goods of non-sanctioned origin. The oil moved. The proceeds needed somewhere to go. That problem required a solution sophisticated enough to survive scrutiny. What the network found, through a chain of introductions that federal investigators would later trace back through 3 offshore referral brokers, was a Chicago law firm willing to provide exactly that. The scheme operated on a principle that federal prosecutors would later describe as privilege laundering. The mechanism exploited a genuine legal reality: wire transfers made between a client and their attorney, characterized as legal retainer payments, enjoy a degree of institutional protection that complicates routine bank compliance review. Financial institutions flagging suspicious transactions are required to file suspicious activity reports, but wires coded as attorney-client retainer payments often receive less scrutiny, not because the law exempts them, but because compliance officers at correspondent banks are conditioned to treat attorney trust accounts as lower-risk channels. Harmon Kreis & Vance weaponized that assumption. Beginning in November 2024, the firm's managing partner, identified in the indictment as Edmund Harmon, 58, began coordinating with 2 named co-conspirators inside the firm: senior partner Lyle Kreis, 62, and international trade partner Adela Vance, 51. The 3 structured a system in which Fiscal Maritime Consolidated would generate invoice packages, formatted as requests for legal retainer payments on pending trade compliance matters, and route wire transfers from a rotating roster of UAE-registered LLCs into a series of IOLTA subaccounts held in the firm's name at 2 Chicago area banks. Each transfer was sized to a specific threshold, $497,000, not $500,000, which would trigger mandatory currency transaction reporting above established bank alert parameters, not $450,000, which might appear too round. $497,000, 11 times, across 11 days, in March 2026, each originating from a different UALC, each landing in the same IOLTA subaccount at a title and escrow company on West Monroe Street in the Loop. The selection of a title company as the receiving institution was not accidental. Title and escrow accounts in Illinois process high volumes of real estate transactions, making large wire transfers statistically unremarkable. A receiving account that processes $40 million in legitimate residential closings per quarter does not ordinarily attract attention for accepting 14 wires of under $500,000 each. Ordinarily. What nobody inside Harmon, Kreis & Vance appears to have calculated was that the specific pattern they'd chosen, 14 identical amount wires, 11-day window, same destination subaccount, would collide with a newly deployed IRS-CI transaction clustering algorithm that had been running in pilot mode at the agency's Chicago field office since January 2026. The algorithm was not looking for Iran sanctions violations. It was looking for structured real estate transaction patterns consistent with beneficial ownership concealment, a different problem entirely. The $497,000 figure had appeared in a separate, unrelated structuring case in Detroit in late 2025, and IRS-CI had flagged it as a watch number in their detection parameters. On March 19, 2026, a junior examiner named Rachel Kwan, assigned to the IRS Criminal Investigation Unit's Chicago office, reviewed the algorithm's output during a routine morning Q check. The flag was marked low priority. She pulled it anyway. I went through the case file, and one detail kept coming back to me. The entire $91 million network unraveled because a junior examiner decided not to skip a low-priority flag on a Wednesday morning. Kwan ran the wire data against public UAE corporate registry records, 14 different LLCs, 14 identical amounts, same destination, same 11-day window. She cross-referenced against FinCEN beneficial ownership filings submitted under the Corporate Transparency Act. The filings for each of the 14 LLCs listed registered agents, formation companies in Delaware and Wyoming, no named beneficial owners. All 14 LLCs had been formed within a 90-day window between August and October 2025. Kwan wrote a 2-page referral memo and sent it to her supervisor before lunch. She included a single handwritten note in the margin of her printed copy. Too clean to be clean. Her supervisor flagged it for escalation the same afternoon. By April 1, 2026, IRS-CI had shared the referral with the FBI's Financial Crimes Unit in Chicago. By April 7th, a joint task force had been authorized. By April 14th, subpoenas had been issued to the 2 correspondent banks holding the firm's IOLTA accounts. What the subpoena returns showed was not 14 transactions. It was 147 transactions, spread across 6 months, totaling $61.3 million in inbound wires, a figure that would eventually be revised upward as agents traced additional channels. The $91 million total reflected proceeds that had moved through not just the IOLTA subaccounts, but through a parallel layer of Delaware shell corporations that the firm had nominally incorporated as client-holding entities for pending real estate acquisitions. Here's what most people assume about money laundering prosecutions. They assume the money moves in big, obvious chunks. The reality, as this case showed, is almost always the opposite. The network's sophistication lay precisely in its granularity. Dozens of small movements, each individually defensible, each individually insufficient to trigger automated enforcement action, accumulating into a sum that by the time investigators mapped it fully, had touched 34 separate legal entities across 3 countries. The money wasn't just moving, it was landing somewhere, and what investigators found when they mapped the destination layer was, in some ways, more alarming than the transit mechanism. The proceeds of the Iranian crude oil sales, after passing through the UAE LLCs, through the IOLTA subaccounts, through the Delaware holding entities, were being reinvested in Chicago area real estate, not commercial real estate, which carries enhanced reporting requirements, residential and mixed-use properties, condominiums in Streeterville and the South Loop, a 12-unit apartment building in Oak Park, a suburban strip mall in Carroll Stream, and one asset that stood apart from the others. A private aviation hangar at DuPage Airport, located in West Chicago, Illinois, approximately 27 miles west of the Loop. The hangar had been acquired in February 2026 through one of the Delaware holding entities for $2.1 million. On paper, it was held by a logistics company with a registered office in Wilmington. The logistics company's sole director was a nominee, a Delaware attorney who served in that capacity for hundreds of similar entities and had no knowledge of the underlying ownership. The hangar's physical operations were managed through a management agreement with a legitimate aviation services company that handled fueling and maintenance contracts for a roster of small charter operators. Federal investigators flagged the hangar in late April 2026 when an FBI analyst cross-referencing the real estate acquisition records against DHS aviation watchlist data noted that 3 of the charter operators using the hangar had filed flight plans to destinations consistent with IRGC-linked logistics routes in the prior 6 months. The connection was circumstantial. Agents added it to the investigation file and kept moving. Put yourself in the lead case agent's position at this point. It's late April. You have 6 weeks of transaction data, a law firm that's been operating as a financial transit node, $61 million in mapped wire transfers, and a private aviation hangar with possible secondary functions. You also have a problem: no direct link between the Chicago law firm's named partners and the IRGC-connected broker in Sharjah. You have the money moving. You need to prove who moved it and why. The link came from an unexpected source. Among the documents subpoenaed from the correspondent banks was a tranche of internal wire instruction records, the routing codes, reference numbers, and memo fields that accompany each transfer at the institutional level. Most memo fields were generic: legal services, retainer, matter ref. One wire, dated January 14, 2026, for $497,000, contained a memo field notation that had apparently been entered in error. It referenced a matter number used by Harmon Kreis and Vance for a client file. The client file number, cross-referenced against the firm's own tax filings obtained through a separate subpoena, resolved to a client identified only as KMC-FZE. Cave Maritime Consolidated. That single memo field entry, a clerical error, an extra 4 characters in a wire reference field, was the thread that connected the money to the name. What's most surprising about this case isn't the scale of the scheme. It's that a network handling $91 million in sanctioned crude oil proceeds was brought down by a memo field that someone forgot to sanitize. By mid-May 2026, the investigation had expanded to include OFAC, the Treasury Department's Office of Foreign Assets Control, as well as the FBI's Counterintelligence Division, which had flagged potential IRGC connections for separate national security review. The case file ran to over 4,000 pages. Agents had conducted 23 interviews, executed 11 financial institution subpoenas, and coordinated with the UAE Financial Intelligence Unit on a mutual legal assistance request for Cave Maritime Consolidated's Dubai area banking records. The obstacles didn't disappear as the investigation deepened. They multiplied. In late May, the Joint Task Force learned that one of the UAE LLCs in the transfer chain had begun the process of voluntary dissolution, a move that would complicate asset recovery if not addressed before the raid. Investigators had to coordinate emergency preservation orders through the Delaware Division of Corporations on a 72-hour window, working over a holiday weekend to prevent document destruction that would have eliminated one entire branch of the money trail. The raid itself, designated Operation Fiscal Veil in internal DOJ communications, was planned over a 3-week window in June. The simultaneous nature of the operation, hitting 6 locations at the same moment, was driven by one overriding concern: the potential for tip-off. By June 2026, task force leadership knew that Harmon Kreis and Vance had at least one contact inside Chicago's federal courthouse community, a former clerk who had socialized with 2 of the firm's partners and who, while not suspected of active cooperation in the scheme, represented a potential information leak if arrest warrants became visible in the system too early. Warrants were sealed under a magistrate-level protective order, The number of personnel briefed on the full operational plan was restricted to 11 people until 48 hours before execution. Here's what strikes me about this case. For all its sophistication, the layered shell companies, the IOLTA exploitation, the privilege laundering, the network's core vulnerability was always human. A junior examiner who pulled a low-priority flag, a wire memo field that wasn't scrubbed, a former clerk who happened to know the right people. These operations don't fail because of the money. They fail because every money trail requires people to touch it. On June 16, 2026, arrest warrants were issued for Edmund Harmon, Lyle Krice, and Adela Vance. Search warrants covered the LaSalle Street office, 4 residential properties, and the DuPage hangar. On June 17 at 11 p.m., agents from the FBI Chicago Field Office, IRS-CI Chicago, and the U.S. Marshals Service began pre-positioning for a 6:14 a.m. simultaneous entry at all 6 locations. The overnight preparation was methodical. Agents assigned to the LaSalle Street location had been conducting passive surveillance on the building's parking garage entry since 9 p.m., logging plate numbers, noting arrival and departure patterns, confirming that no unusual vehicle traffic suggested a tip-off had reached the subjects. Surveillance teams maintained visual contact on each location from before midnight. A tactical element assigned to the DuPage hangar reported at 2:30 a.m. that the facility appeared unoccupied, consistent with prior surveillance. Residential teams observed that all 4 properties were dark by midnight, suggesting the subjects were home and unaware. At 5:45 a.m., all teams confirmed readiness on encrypted radio channels. At 6 a.m., the command center in the FBI's Roosevelt Road facility gave a 14-minute warning. At 6:12 a.m., final go authorization was transmitted. At 6:14 a.m., all 6 entries began within an 18-second window of each other. At 190 South LaSalle, the lobby team moved first. Edmund Harmon was in the elevator, ascending from the parking garage to the 14th floor, when FBI agents stepped into the car at the lobby level. He was placed under arrest before the elevator reached the 4th floor. Lyle Krice was at his desk, apparently reviewing documents, when agents entered the suite. He was arrested without resistance. Adela Vance was in a conference room at the back of the floor, on a phone call. Agents terminated the call. The counterparty's identity was logged as an investigative lead, and arrested her at the conference room table. At the same moment, agents at Harmon's Evanston residence executed the search warrant and recovered 2 laptops, a portable encrypted drive, and a physical ledger book with handwritten entries that would later be characterized by prosecutors as a reconciliation record of disbursement cycles. At Krice's Gold Coast condominium, agents found $2.3 million in cashier's checks in a fireproof safe in the master bedroom closet. A second safe, bolted to the floor of a utility closet near the building's service entrance, contained a prepaid phone with 6 stored contacts, none of them identified by name. The checks were made out to 3 different Delaware entities. 2 of the entities were already in the investigation file. The DuPage hangar search produced no aircraft. The hangar was empty. But agents recovered filing cabinets containing printed shipping manifests, bill of lading copies, and correspondence in Farsi that would require translation. The manifests listed cargo descriptions inconsistent with the listed vessel origins. Investigators photographed and seized everything. By 8:30 a.m., all 3 subjects were in federal custody. The total seizure from all 6 locations included 34 servers, 7 laptops, 4 portable encrypted drives, $2.3 million in cashier's checks, the Evanston ledger book, and 12 boxes of physical files containing billing records, wire transfer confirmations, and internal correspondence. The search at the LaSalle Street offices continued until 4 p.m. A team of 8 evidence technicians worked through the firm's records storage room, flagging documents by matter number against a pre-prepared reference list of the 34 Delaware entities identified during the investigation. Late in the afternoon, one technician located a binder in a filing cabinet drawer that contained printed copies of every wire transfer in the network from November 2024 through May 2026, organized by month, with handwritten annotations indicating the disbursement destination for each transfer. The annotations used a shorthand notation. Investigators spent 3 days decoding the notation before concluding it matched the real estate acquisition records they had already mapped. The binder was the single most comprehensive piece of physical evidence recovered in the operation. Prosecutors would later describe it, in the language of their sentencing memorandum, as a disbursement ledger maintained by the defendants for their own internal reconciliation, an act of record-keeping that proved, beyond any evidentiary ambiguity, the defendant's active knowledge and direction of the scheme. There's a line in the indictment that reads almost like fiction. Edmund Harmon had been maintaining a printed record of the network's transactions, in a physical binder, in a filing cabinet, in a law firm office, because he apparently trusted attorney-client privilege to make that filing cabinet untouchable. He was wrong, and he may not have fully understood why until the morning of June 18th. The legal argument that privilege protected the records failed at the first hearing. The crime-fraud exception to attorney-client privilege, which removes protection from communications made in furtherance of an ongoing crime, had been anticipated by investigators from early in the case. Prosecutors presented the exception argument at a sealed hearing before the search warrants were issued. The magistrate agreed. The binder, the servers, the billing records, all of it admissible. This was the first time, in a federal Iran sanctions prosecution, that attorney-client privilege had been successfully pierced at the pre-raid authorization stage, rather than through post-arrest litigation. The legal precedent set by the magistrate's ruling, that a law firm's billing records and internal correspondence are not privileged when the billing function itself is the laundering mechanism, was noted in the DOJ press release as a significant development in financial crimes enforcement methodology. Here's an unpopular opinion. The privilege argument should never have been as legally uncertain as it apparently was. When the legal work is the laundering, when the invoice is the crime, there's no genuine privilege question. The fact that this required a novel ruling at the federal magistrate level suggests the legal framework around attorney trust accounts has lagged badly behind the financial architecture that sophisticated actors have built to exploit it. Edmund Harmon, Lyle Kreis, and Adela Vance were indicted on June 25, 2026, on charges including conspiracy to violate the International Emergency Economic Powers Act, bank fraud, money laundering conspiracy, and structuring. The indictment named Cave Maritime Consolidated FZE and its beneficial owner, identified as Iranian national Dariush Mahmoodian, operating under a UAE passport and a second document of unspecified origin, as co-conspirators. Mahmoodian was not in custody as of the indictment date. He was believed to be in Sharjah or in transit. OFAC simultaneously designated Cave Maritime Consolidated and its 4 known affiliate entities under Iran sanctions authorities. The designation froze any U.S. accessible assets and prohibited dealings by U.S. persons, a step that, at this stage of the investigation, was largely symbolic, since the network's liquid assets had already been seized or encumbered. Did the legal system's reliance on self-reporting mechanisms in the financial sector make an operation like this inevitable? Comment below. The people who built the compliance frameworks this network exploited have been asking themselves the same question. The recovered assets at the time of the indictment totaled approximately $34 million. The Chicago area real estate holdings identified during the investigation, the $2.3 million in cashier's checks, and funds held in 2 of the IOLTA sub-accounts that had not yet been disbursed. The remaining $57 million in proceeds, already moved through the network and reinvested, or transferred to destinations not yet fully mapped, was characterized in the government's asset forfeiture filing as subject to ongoing tracing. $57 million, not recovered, not frozen, not located. 3 obstacles had nearly derailed the investigation before it reached the raid stage. The emergency preservation orders over the holiday weekend, the restricted briefing window to prevent courthouse leaks, and one additional complication that didn't make the press release. In the final week before the raid, one of the 4 residential search warrant subjects, a property in the name of one of the Delaware entities, believed to be used by a network associate, not among the 3 primary targets, was found to have been vacated. Furniture removed, utilities disconnected. The property was empty by June 12th, 6 days before the raid. Whoever had been using it was gone. That individual has not been identified. Federal investigators declined to comment on whether they had a name. The network, as mapped by investigators, involved the participation of at least 2 additional intermediaries outside the United States, individuals who facilitated the routing of proceeds from the crude oil sales through the UAE El Tulayer before the funds entered the U.S. banking system. Neither of those intermediaries has been charged. Their identities, if known to investigators, have not been disclosed in public filings. The DuPage hangar remains under active investigation. The Farsi language manifests recovered during the search have been translated and referred to the FBI's Counterintelligence Division. No public charges have been filed in connection with the hangar's operations. No aircraft linked to the property has been identified. Whatever the hangar was being used for, or prepared to be used for, that question remains open. Will the unidentified network associate who vacated that residence before the raid be found? Comment yes or no. We read every one. The case of Harman Kreis and Vance LLP showed, in technical detail, how an established professional services firm can be converted into a financial infrastructure node for a sanctioned foreign government's revenue stream, without a single person outside the firm's senior leadership knowing it was happening. The 41 attorneys who were not among the 3 arrested partners continued to represent clients, bill hours, and file motions in routine matters throughout the 18 months the scheme was running. The compliance staff processed wire transfer requests through the normal approval chain, flagging nothing because the invoice documentation was consistent with what legitimate retainer payments look like. That's the architecture. That's the design. A machine built to look unremarkable at every individual point of contact, accumulating a function that was the opposite of unremarkable. The 3 partners will face sentencing proceedings in a federal courtroom. The Iran sanctions framework that the scheme exploited has not been modified. The compliance gap between attorney trust account reporting requirements and standard financial institution SAR obligations has not been closed. The beneficial ownership concealment infrastructure, Delaware LLCs with nominee directors, formation companies with no visibility into actual use, remains fully operational and available to anyone who wants it. The network is dismantled. The architecture that made it possible is still in place. If you want to follow what comes next, the sentencing, the asset tracing, and whatever the DuPage investigation eventually surfaces, subscribe. This channel tracks what happens after the press release stops.